The pre-trial chamber of the extraordinary chambers in the courts of Cambodia is pronouncing two decisions. One, decision on civil party participation in provisional detention proceedings. Two, decision on the Nuon Chea's appeal against the provisional detention order. In pronouncing these decisions, we are going to read certain parts of the entire decisions. Whereas the detailed decisions are to be made available to the public at a later stage. Attention to the charged person. Stand up, please. During this hearing, you may take a seat if you wish. Please sit down. The decision on civil party participation in provisional detention proceedings.
The pre-trial chamber refers first to recall the procedural steps which have been taken by the parties and the chamber. The pre-trial chamber summarizes all the submissions made by the parties on the matter. The pre-trial chamber refers to all the amicus briefs which were received. The pre-trial chamber summarizes all the submissions of all the parties responding to the first submissions. The pre-trial chamber gives an overview of relevant internal rules, articles of Cambodia procedure and practice, International Standard Party referring to UN Victims Declaration, and basic principles for victims dated 16 December 2005. Further, the pre-trial chamber mentions articles related to the structure of victim participation in the ICC statute, the UNCHEA regulation in the transitional rules of criminal procedure of East Timor, and the Provisional Criminal Procedure Code of Kosovo.
The pre-trial chamber see that the scope of decision is related to Rule 23.1,
where it reads, the purpose of civil party action before the ECCC is A, participates in criminal proceedings by supporting the prosecution, question raised is whether this includes the possibility of civil parties to participate in the appeal against the provisional detention order in the case of the charged person. The pre-trial chamber finds that the test of Internal Rule 23(1)A is clear in its wording, that civil parties can participate in all criminal proceedings, which includes the procedure related to appeals against provisional detention before the pre-trial chamber. The jurisdiction of the pre-trial chamber in the internal rules regarding provisional detention appeals was based on the jurisdiction of the investigation chamber. The pre-trial chamber can, therefore, seek guidance for its functioning in the articles of the CPC prescribed for the investigating chambers. The CPC
Please apologize because we had some technical problem in the translation part. I would like now to resume.
ការបញ្ចូលដើមបណ្ដឹងរដ្ឋវិន័យក្នុងនីតិវិធីជាការទទួលស្គាល់ការបន្តការបង្រួបបង្រួមជាតិ
The pre-trial chamber notes that the inclusion of civil parties in proceedings is in recognition of the stated pursuit of national reconciliation. The pre-trial chamber finds that the text of Internal Rule 23(1)A is clear in its wording, that civil parties can participate in all criminal proceedings, which includes the procedure related to appeals against provisional detention before the pre-trial chamber. The pre-trial chamber further considers that the provision in the internal rules quoted in paragraph 20 to 26 makes it clear that civil parties have active rights to participate starting from the investigation phase of the procedure. The pre-trial chamber notes that the inclusion of civil parties in proceedings is in recognition of the stated pursuit of national reconciliation. The pre-trial chamber has no jurisdiction to examine the internal rules in full regarding victim participation, but merely to examine the issue as outlined above. The jurisdiction of the pre-trial chamber in the internal rules regarding the jurisdiction of the pre-trial chamber and internal rules regarding the provisional detention appeals was based on the jurisdiction of the investigation chamber. The pre-trial chamber can therefore seek guidance for its functioning in the articles of the CPC prescribed for the investigating chambers. In the CPC, there is a provision in Articles 259 and 260 for the civil parties related to participation in appeals against detention orders. Reading Rule 23.1 in the light of the CPC means that the wording envisages participation of the civil parties during the proceedings of the ECC, including appeals against provisional detention orders. According to Article 12 of the ECCC agreement, there is an obligation for the pre-trial chamber to see whether the CPC is consistent with international standards on this issue. If the pre-trial chamber is to seek guidance from the CPC. What's the reading?
I would like to read this again.
The pre-trial chamber finds that Internal Rule 23.1, when read to include participation in proceedings or appeals against detention orders, is consistent with the international guidelines concerning civil party participation in criminal proceedings set out in paragraphs 30 and 31 above. Furthermore, it is consistent with procedural rules of the international tribunals mentioned in paragraphs 32, 33, and 34. The internal rules differ in some procedural respects from those of other courts, but not in respect of this principle of civil party participation during the detention phase. Considering this international practice, civil party participation during the detention phase must, in addition, be regarded as generally complying with fair trial principles. In general, it is further accepted that civil parties may have interest in the outcome of an appeal against a detention order. The pre-trial chamber notes that internal rules differ from the CPC and the aforementioned provisions insofar as there is no provision for the civil parties to participate in adversarial hearing before the co-investigating judges before the ECCC. Internal Rule 63.1 provides for the co-investigating judges to hear only the the co-prosecutors, the charge person, and her lawyer, his or her lawyer, close quotes. Where an investigation is commenced by the co-prosecutors on the basis of a complaint, there is no procedure for the complaint to be informed, the complainant to be informed of whether this has been followed by a judicial investigation. By operation of the internal rules, any prospective civil party will first become aware of any judicial investigation against a specific charged person upon the notification of the issuing of a provisional detention order, as is provided for in Rule 46. That civil party participation is only possible and provided for in the internal Rule 23.3 from and after the commencement of a judicial investigation, and, in effect, after an order has been made under Rule 63. Where a charged person has made an appeal against a provisional detention order, as provided for in Internal Rule 63.4, the civil parties will have the right to participate. At this point, the appeal forms part of the criminal proceedings, as provided for in Internal Rule 23.1. The effect of this participation of the civil parties in an appeal against a provisional detention order is that the charged person is confronted with matters which may not have been previously submitted at the adversarial hearing before the co-investigating judges. This is a matter that could cause an imbalance in the procedures and the right to a fair trial. But such participation of civil parties is authorized, and the procedures adopted by ECCC must allow for this. The internal rules provide the pretrial chamber with the means of ensuring that any apparent imbalance or unfairness can be addressed. A charged person is permitted to respond to submissions made by any civil parties. It is provided by Internal Rule 74.4 that all parties, and this will include the civil parties, must file written submissions with the greffier of the pre-trial chamber before the hearing on the appeal. At all times, the pre-trial chamber can allow the charged person to provide written or oral submissions in response where the interests of the charged persons are involved. Even when new issues are raised during the hearing. In this way, the interest of the charged person can be protected without having a prescriptive procedure adopted, which can potentially cause problems and can be concluded from the experience of the ICC. The pre-trial chamber is additionally guided by the provisions of Internal Rule 21.1a, which provides that ECCC proceedings shall be fair and the adversarial and preserve a balance between the rights of the parties. The pre-trial chamber finds that the right of the charged person to a fair trial is therefore sufficiently guaranteed in the internal rules and balanced with the rights of civil parties to written and oral participation in the proceedings before the pre-trial chamber dealing with an appeal against the detention order. The procedures of the pre-trial chamber were followed as related in paragraphs 1 to 4 of this decision. A few days before the hearing, lawyers were appointed for the civil parties, and they indicated that they wished to be heard. The pre-trial chamber made such directions as were necessary to ensure that the rights of the charged persons were not adversely affected. In the instant case, the charged person was confronted with the fact that civil parties could make oral submissions after the co-lawyers made their initial submissions during the hearing prior to the hearing. But the civil parties did not file written submissions. The co-lawyers complained about permitting the civil parties to orally submit their views. The pre-trial chamber requested the lawyers of the civil parties to deliver copies of the written versions of their oral submissions. The contents of their submissions were taken into account by the pre-trial chamber, and the parties were addressing the chamber concerning the asserted right by the civil parties to participate in the appeal. The pre-trial chamber decided to continue the hearing of the appeal with the participation of the civil parties, with agreement from all parties. The contents of the submissions of the civil parties disclose their awareness of their duty to only address relevant issues regarding the interests of the civil parties in the issues dealt with. This does not foreclose the possibility that the civil parties will, in the future, be encouraged or required to join their submissions when they share the same views in order to enhance efficiency of the proceedings. The rights of the civil parties were preserved by permitting the rights of the charged person were preserved by permitting him to make further written submissions addressing the ability of the civil parties to be heard on the appeal. Additionally, the charged person exercised the rights given by the pre-trial chamber to respond to the submissions of the civil parties during his initial oral submissions. The rights of the charged person to a fair hearing were thus balanced and protected, and not violated as asserted by him. The pre-trial chamber finds that according to Internal Rule 23.3, it is the decision of the investigating judges to approve the application of the civil parties. There is no possibility for the charged person to appeal this decision. The pre-trial chamber therefore has no jurisdiction to determine whether the co-investigating judge's assessment was not made in accordance with the rules as asserted by the co-lawyers. The co-lawyers asserted that difficulties may arise in the future if the number of civil parties increases. The pre-trial chamber has reflected upon the implications of this decision for the future. In exercising this jurisdiction, the pre-trial chamber cannot speculate on facts that may or may not be presented to it in the future. As its jurisdiction is limited to only matters that have occurred and not those that may occur. Unlike the ICC statutes, the internal rules provide that once admitted, a civil party may participate in all stages of the proceedings according to Internal Rule 23.4. There is no need to show any specific interest in any stage of the proceedings as asserted by the co-lawyers. Therefore, the pre-trial chamber hereby decides unanimously the request of the charged person to 1. Exclude the civil parties' submissions from the record of the Nuon Chea appeal, and 2. Preclude any further participation that the civil parties in proceedings related to the provision of detention are refused, given in public by the pre-trial chamber.
The decision on the appeal against the provisional detention order.
The PTC refers first to call the procedural steps which have been taken by the parties and the chamber. The PTC summarizes all the submissions made by the parties on the matter. In its decision, the PTC refers to all the dates in which documents were received and hearings were held. The PTC has found the appeal admissible. The nature of the appeal. The pre-trial chamber will review the provisional detention order by an examination of A, the procedure of the co-investigating judges prior to the order being issued. B, the sufficiency of the facts for ordering provisional detention under Rule 63(3). C, whether the circumstances on which the order was based still exist today. And D, the exercise of discretion by the investigating judges in applying internal Rule 63(3). During the hearing, the co-lawyers submitted that the fundamental notions of fair trial appear to have been, in practice, overlooked or neglected in certain proceedings before the pre-trial chamber. They refer to the speediness of the dismissal of the motion for disqualification of a judge in this case, and the decision on the appeal in the case of King Gert. They submit that this decision appears to be reasoned, logical, and fully comprehensible, but some factual findings which they specified seem to suggest that opinions have already been formed on core issues in this case, They further urge the pre-trial chamber to respect the presumption of innocence in its language. Both the adversarial hearing and the opportunity to appeal its outcome give the charged person the possibility to have the lawfulness of his detention reviewed by a court, a right provided for by Article 9 of the International Covenant on Civil and Political Rights. Or ICCPR. Moreover, Article 9 of the ICCPR requires that such review is without delay. It is therefore not understood how the co-lawyers can conclude that the speediness of making a decision leads to neglecting or overlooking fundamental notions of fair trial. The fact-finding referred to by the co-lawyers in a previous case dealt with by the pre-trial chamber is related to the presented evidence and the position of the charged person in that case. Decisions of fact in one case provide no decision in respect of another case. The co-lawyers submitted conclusions on facts determined in a previous case without reference to the reasoning of the pre-trial chamber, and in so doing failed to disclose the context. Each case before the pre-trial chamber is determined upon the evidence before it in that case. In the instant case, the pre-trial chamber will do the fact-finding by examining the presented evidence and the position of the charged person and the other parties in respect of this evidence. There can therefore be no conclusion that the right to a fair trial of the charged person would be overlooked or neglected by the predetermination of facts. According to Rule 63(1) of the Internal Rules, the co-investigating judges may order the provisional detention of a charged person after an adversarial hearing. Internal Rule 63(1) provides the co-investigating judge may order the provisional detention of a charged person after an adversarial hearing. If the charged person does not yet have the assistance of a lawyer, he or she shall be advised of the right to a lawyer as provided by Rule 21(1)(d). The charged person has a right to a reasonable period in order to prepare his or her defense. During the hearing, the co-investigating judges shall hear the co-prosecutors, the charged person, and his or her lawyer. At the end of the hearing, the co-investigating judges shall decide on provisional detention. If provisional detention is not ordered, the charged person shall be released. If the co-investigating judges decide to order provisional detention, they shall issue a detention order. A question raised by the appeal is whether the charged person's decision to proceed with the adversarial hearing without the assistance of a lawyer may be regarded as a legally valid waiver of the right to legal assistance. The pretrial chamber notes that the co-lawyers of the charged person and the co-prosecutors have different interpretations of the facts relating to the waiver given by the charged person during his initial appearance and the adversarial hearing according to the records of the co-investigating judges. During an in-camera hearing, the pre-trial chamber viewed parts of the video recording of his initial appearance and the adversarial hearing that related to this waiver. The pre-trial chamber has seen that neither the interpretation of the events by the parties nor the written records provide a complete picture of what actually occurred in this context. The pre-trial chamber therefore relies on the video recordings that were viewed in court and sets out the transcript of what was heard through interpretation during the hearing. The pre-trial chamber will use this information as evidence of what happened during the hearing in deciding on the validity of the given waiver. In its decision, the PTC has set out the transcript of what the PTC has seen on the video of the initial and adversarial hearing. Internal Rule 63(1) does not specifically mention the possibility of a waiver. In contrast to Rule 58(2) of the internal rules relating to interviews of the charged person. Rule 58(2) provides in relevant part, a charged person shall only be questioned in the presence of his or her lawyer, unless the charged person waives the right to the presence of a lawyer in a separate written record signed by the charged person, included in the case file. The waiver shall be recorded pursuant to Rule 25. The pre-trial chamber finds that Internal Rule 58(2) does not apply to the adversarial hearing on provisional detention. An adversarial hearing is distinct in its purpose from an interview of the charged person. An adversarial hearing gives the charged person the opportunity to respond to the request of and the arguments made by the co-prosecutors. An interview is held as part of investigations by the co-investigating judges to find the truth and therefore aimed at obtaining a statement from the charged person, a statement that could be used as evidence against him. While Rule 58 of the internal rules may be interpreted to apply to any questioning of the charged person, irrespective of the procedure, it does not apply in this case, since the charged person was not questioned during his adversarial hearing. Thus, the requirement of Rule 58 of the internal rules for a waiver of the right to a lawyer to be separately recorded in writing, signed by the charged person, do not apply in this case. The pre-trial chamber finds that the possibility of the waiver of the right to a lawyer during the adversarial hearing can be inferred from Rule 63(1). According to this rule, a charged person without a lawyer shall be advised of his right to have one, and can therefore waive his right. The trial chambers of the International Criminal Tribunal for the former Yugoslavia, ICTY, and the International Criminal Tribunal for Rwanda, ICTR, have both examined the validity of waivers of the right to a lawyer. The pre-trial chamber observes that the tribunals apply different criteria for the waiver in different stages of the proceedings. In Bagasora, the trial chamber of ICTR considers that, to be effective, a waiver should be voluntary and unequivocal. In this case, Bagasora, as a suspect, waived his rights to a lawyer during questioning. With regard to the requirement that the waiver must be unequivocal, the trial chamber considered that the waiver must be shown convincingly and beyond reasonable doubt. It must be express and unequivocal, and must clearly relate to the interview in which the statement in question is taken. The trial chamber pointed out that according to national jurisdictions, a waiver cannot be voluntary unless the detainee knows of the right to which he is entitled. The trial chamber further observed that to be so informed, the suspect must be informed that the right includes the right to the prompt assistance of counsel prior to and during questioning. Any implication that the right is conditional or that the presence of counsel may be delayed until after questioning renders any waiver defective. The trial chamber of the ICTY was faced with a different situation in the case of Skleisnik. In this case, the accused requested to proceed with his trial unrepresented by counsel. The trial chamber considered that before a request to proceed unrepresented by counsel may be addressed on its own terms, both the law and common sense indicates a preliminary inquiry to determine whether the request is unequivocal, informed, and intelligent. Although the trial chamber did not link these requirements specifically to the waiver of the right to a lawyer, The pre-trial chamber observes that U.S. case law referred to by the trial chambers does. The pre-trial chamber therefore considers that the trial chamber's inquiry and the applied requirements relate to the waiver of the right to a lawyer. The pre-trial chamber observes, however, that Kreisnick's waiver was made in the trial stage. The trial chamber of the ICTY subsequently considered that equivocal means unclear in meaning or intention, ambiguous. A request which is formulated conditionally or in the alternative may lack nothing in clarity. But where a court is not persuaded that the applicant actually desires the alternative of self-representation, the court has little choice but to find the request unclear in meaning or intention, ambiguous, and therefore equivocal. The trial chamber noted, with regard to the requirements of informed and intelligent assistance of counsel, the alternative may lack nothing in clarity. But where a court is not persuaded that the applicant actually desires the alternative of self-representation, the court has little choice but to find the request unclear in meaning or intention, ambiguous, and therefore equivocal. The trial chamber noted, with regard to the requirements of informed and intelligent, and voluntary. Intelligent. The pre-trial chamber is of the view that the trial chambers applied the requirements of an unequivocal waiver in similar ways and will in this case apply their interpretations. With regard to the requirement of voluntariness, the chambers applied different standards. Where in Bagasora it was held sufficient to inform a suspect of the right to a lawyer, in Kreisnick, a higher standard was applied, requiring information on financial and practical consequences of proceeding without a lawyer before an intelligent decision could be made. In this respect, as mentioned above, the case dealt with waivers in different stages of the proceedings. In Bagasora, the waiver was related to the questioning of a suspect. In Kreisnick, the waiver was related to the exercise of the right of self-representation. The pre-trial chamber finds that the stage of the proceedings determines the information required to constitute an informed waiver. In the case of questioning, it's clear that proceeding without a lawyer could result in incriminatory evidence being elicited improperly. In order to knowingly and intelligently waive the right to a lawyer, the charged person must be able to make a rational appreciation of the effects of proceeding without a lawyer. An adversarial hearing is necessary before ordering provisional detention. The adversarial hearing gives a charged person the opportunity to respond to the co-prosecutor's request to have such an order issued. After hearing the submissions of the parties, the co-investigating judges may order the provisional detention of the charged person. During the initial appearance and adversarial hearing of the charged person, the co-investigating judges repeatedly informed the charged person of his right to a lawyer and asked whether he required a lawyer. The co-investigating judges furthermore informed the charged person of the purpose of and procedures during the adversarial hearing, and that it was in his interest to proceed with a lawyer. The pretrial chamber therefore finds that the waiver of the charged person was informed. Although the charges faced by the charged person in this case are of a complex nature, he waived his right to a lawyer during the adversarial hearing. At this moment, there is no information in the case file, including the video recording of the hearing of the co-investigating judges, and nothing presented by the core lawyers that leads to the conclusion that the charged person is hampered by his old age, his medical condition in making decisions. During the appeal hearing, the co-lawyer submitted that the charged person has told the DSS prior to the initial hearing that he was not fit to proceed. According to the redacted DSS meeting notes submitted by the co-lawyers after the hearing, the DSS informed the charged person that he could ask the co-investigating judges to delay the proceedings. The charged person subsequently requested the DSS to proceed the co-investigating judges to persuade, the co-investigating judges to give him time to rest. The meeting notes mention that the DSS advised the office of the co-investigating judges of this request by telephone. The pretrial chamber observes that the DSS meeting concluded at 1 p.m. and the initial appearance commenced at 2:40 p.m. During the hearings, according to the video recording, the charged person did not ask the co-investigating judges to adjourn, despite being offered this possibility with respect to the adversarial hearing. This possibility to adjourn was not seized by the charged person. Furthermore, the charged person did not mention to the co-investigating judges that he was not feeling well, nor was this mentioned by the co-investigating judges. The pretrial chamber therefore finds there is no evidence that the charged person was unable to give a valid waiver due to his physical condition. The pretrial chamber considered the charged person who is educated and who in the past held a high political position armed with the information provided as mentioned above within the context of the adversarial hearing, had a rational and fully informed appreciation of the consequences of proceeding without a lawyer. The charged person repeatedly asserted that he could proceed without a lawyer for those specific proceedings, that his co-lawyers would represent him for all future proceedings. The pre-trial chamber finds that these assertions demonstrate that the charged person wanted to waive his right to a lawyer, and that this decision was unequivocal. In conclusion, the pre-trial chamber finds that when taking the requirements of the waiver and the circumstances of the case into account, the charged person's waiver was unequivocal and voluntary, and therefore valid. A well-founded reason to believe that the person may have committed a crime or crimes specified in the introductory or supplementary submission. The pre-trial chamber observes that the internal rules do not explain what constitutes well-founded reason. In this regard, the pre-trial chamber notes that the French version of the internal rules uses raison plausible for the term well-founded reason, a term that corresponds with the term used in Article 5 of the European Convention of Human Rights. This article provides inter alia toute personne a droit de liberté et la sûreté. The pre-trial chamber observes that the internal rules do not explain what constitutes well-founded reason. In this regard, the pre-trial chamber notes that the French version of the internal rules uses raison plausible for the term well-founded reason, a term that corresponds with the term used in Article 5 of the European Convention of Human Rights. This article provides inter alia, read in French, Toute personne a le droit à la liberté et la sûreté. Nul ne peut être privé de sa liberté dans le cas suivant et selon s'il a été arrêté et détenu en vue d'être conduit devant l'autorité judiciaire compétente. Lorsqu'il y a des raisons plausibles de soupçonner qu'il a commis une infraction ou qu'il y a des motifs raisonnables de croire à la nécessité d'empêcher de commettre une infraction ou de s'enfuir après l'accomplissement de celle-ci. The European Court of Human Rights, ECHR, has consistently held that l'existence de soupçons plausibles présuppose celle de faits ou renseignements propres à persuader un observateur objectif que l'individu en cause peut avoir accompli l'infraction. The pre-trial chamber observes that the internal rules do not explain what constitutes well-founded reason. In this regard, the pre-trial chamber notes that the French version of the internal rules uses raison plausible for the term well-founded reason, a term that corresponds with the term used in Article 5 of the European Convention of Human Rights. This article provides, inter alia, read in French, toute personne a le droit à la liberté et la sûreté. Nul ne peut être privé de sa liberté, sauf dans le cas suivant et selon les voies légales. S'il a été arrêté et détenu en vue d'être conduit devant l'autorité judiciaire compétente. Lorsqu'il y a des raisons plausibles de soupçonner qu'il a commis une infraction ou qu'il y a des motifs raisonnables de croire à la nécessité d'empêcher de commettre une infraction ou de s'enfuir après l'accomplissement de celle-ci. The European Court of Human Rights, ECHR, has consistently held that l'existence de soupçons plausibles présuppose celle de faits ou renseignements propres à persuader un observateur objectif que l'individu en cause peut avoir accompli l'infraction. Ce qui peut passer pour plausible dépend toutefois de l'ensemble de circonstances. In the recent decision of the Pre-Trial Chamber of the International Criminal Court, ICC, in the case of Ahmad Mohamed Harun, and Ali Mohamed Ali Abdul Rahman, or Ari Kusai, the Chamber considered it was required to interpret the statute's expression for well-founded reason, reasonable grounds to believe, in accordance with internationally recognized human rights. The Chamber held. Thus, In interpreting and applying the expression reasonable grounds to believe, the chamber would be guided by the reasonable suspicion standard under Article 51C of the European Convention on Human Rights and the jurisprudence of the Inter-American Court of Human Rights on the fundamental right to personal liberty under Article 7 of the American Convention on Human Rights. The Free-Trial Chamber will, as the ICC has done, interpret the words well-founded reason by seeking guidance in the above-mentioned jurisprudence of the ECHR. This means that the Free-Trial Chamber has to decide whether facts or information exists which would satisfy an objective observer that the person concerned may have committed the offense. Rule 63(3)A of the internal rules requires furthermore that this well-founded reason is related to the belief that the charged person may have committed the crime or crimes as specified in the introductory submission. In accordance with Article 29 of the law on the establishment of the extraordinary chambers of the courts of Cambodia of 27 October 2004, the term committed includes planning, instigating, ordering, aiding and abetting, or committing, and superior criminal responsibility. The Free-Trial Chamber notes, in order to ensure that the investigation is not compromised, that in this public decision will not set out the evidence related to the specific alleged crimes in the introductory submission or the contextual elements of the charged crimes. After an examination of the case file, the Free-Trial Chamber is satisfied that there is well-founded reason to believe that the specific alleged crimes mentioned in the introductory submission may have been committed in the context of an international armed conflict and or as part of widespread and systematic attacks on discriminatory grounds. The co-lawyers did not contest the alleged facts set out in introductory submission. Rather, they contested the alleged involvement of the charged person in respect of such matters. The PTC, the Free-Trial Chamber, reasons in its decision further that well-founded reasons are found that the charged person has responsibility related to these crimes. The Free-Trial Chamber has further examined the evidence in the case file and concludes that all the grounds for provisional detention are made out, as can be read in detail in the decision. Therefore, the Free-Trial Chamber hereby decides unanimously the appeal. 1. The appeal is admissible in its form. 2. The co-investigating judges properly exercise their discretion to order the provisional detention of the charged person. 3. The grounds for provisional detention are still satisfied. 4. The order of the co-investigating judges is affirmed with the reasons expressed in this decision being substituted for the reasons of the co-investigating judges. 5. The appeal is dismissed. In accordance with Rule 7713 of the Internal Rules, this decision is now subject to appeal. Given in public by the pretrial chamber in the presence of the charged person and his co-lawyers.
Please, the security guard take the charged person to the detention facility.